Furman versus Georgia is a landmark case because it was the first and only time in American history that the Supreme Court declared the death penalty unconstitutional, which meant that in all of the places that it was then practiced, which was 40 states and the federal government, it disappeared overnight. There's a story there because, as we all know, the death penalty is still quite alive and well here in the United States. So Furman was not the end of that story, but it was certainly a major landmark along the way. So the death penalty is an anomaly in American law in a number of ways. We've had it since the inception of the country. At the time of the founding of the country, every one of the 13 colonies had the death penalty. In most criminal cases, as most people know from watching like Law and Order on TV, judges do the sentencing. So the jury will decide whether someone is guilty or not guilty, and if they're found guilty, then the judge, generally in most state systems and in the federal system, imposes the punishment. One main exception to that is capital punishment. It has been a long tradition in the United States that juries tend to be the ones imposing the death penalty. And prior to Furman versus Georgia, juries were given complete discretion as to whether someone should get the death penalty for a crime versus some lesser punishment.
In the event that you find the accused guilty, the death sentence is mandatory in this case.
For most of American history, no one thought that the Constitution had anything to say about the death penalty. The death penalty appears to be mentioned in the Constitution because the due process clauses of both the Fifth and the 14th Amendment say you cannot be deprived of life, liberty, or property without due process of law, which seems to suggest that you could be deprived of life, liberty, or property if there is due process of law. In the 1960s, suddenly, there was a decision, not really a decision, a non-decision by the Supreme Court that started the whole challenge in motion. In 1963, Justice Arthur Goldberg wrote a dissent from denial of certiorari. So a denial of certiorari is a decision by the Supreme Court not to hear a case, but justices can dissent from the court's refusal to hear a case, and that's what Justice Arthur Goldberg did in a case called Rudolph versus Alabama. You need 4 justices to grant cert. The court declined to grant cert, but 3 justices, Arthur Goldberg, joined by William Brennan and William O. Douglas, wrote a dissent from denial of cert, saying that they thought the court should decide this question. That really got the attention of the nation's premier civil rights group, the NAACP Legal Defense and Education Fund, known as the LDF. They knew, as everyone in the United States knew, that the death penalty was a racial issue. Rudolph versus Alabama, a black man sentenced to death for raping a white woman. This was the typical use of the death penalty, especially in cases of rape. So the LDF started a nationwide campaign, a litigation campaign across the country to challenge the death penalty constitutionally. This strategy was tremendously successful. The death penalty was in decline already in the 1960s in the United States, as it was in Europe, but the LDF's litigation campaign brought it to a complete halt. So from 1967 to 1972, in the 5 years prior to the decision in Furman versus Georgia, there were no executions in the United States. The LDF was raising every possible constitutional issue they could think of, and I'm not going to list them all. There were a lot. And the Supreme Court started granting cert on them. And it looked, and this is the exciting part of the story, it looked in 1971 like the LDF lost because the Supreme Court granted cert and decided a case called McGautha versus California, which decided exactly the same kind of challenge that was litigated in Furman, but under the Due Process Clause. So that was the same claim that the lawyers had brought in Furman under the Eighth Amendment. But since the court had just rejected that claim under the Due Process Clause, most people thought that Furman didn't have a chance. Of course, they turned out to be wrong about that. Two of the justices who had been in the majority in McGautha rejecting that claim changed their minds, and the following year voted in favor of that same claim about lack of standards guiding capital sentencing juries in Furman itself. Stewart and White, along with Justices William Brennan, Thurgood Marshall, and William O. Douglas, made the 5 justices in the majority in Furman to declare the American death penalty unconstitutional in 1972.